Now let's talk about how a technology transfer office actually operates, the workflow, decision factors, and services you can expect to receive. As we consider the workflow of a technology transfer office, please understand that the specifics may differ across institutions, but the basics are similar. Some of the key components when you're going through the process or engaging with your technology transfer officer are the IP decision factors, the role of public disclosure, and the TTO support services that are available to you. For more information on public disclosure, please take a look at the video archives. When making decisions regarding a faculty disclosure, the Technology Transfer Office considers three things: the observable or anticipated value of the intellectual property, social and/or economic, the intellectual property landscape and literature gathered through patent searches, and any freedom to operate challenges that may exist. So, how does the Technology Transfer Office help? It provides IP education and resources, reviews and screens invention disclosures, covers the upfront cost for IP protection, manages agreements between parties, and facilitates some elements of early stage commercialization. When providing details about your invention to the Technology Transfer Office, you will typically complete a disclosure form. Submitting a disclosure is the key step in starting the process that could potentially lead to commercialization of your technology. Completing the form helps the TTO in two important ways. It serves as a written dated record of your invention, and it provides the TTO with the basic information needed to evaluate, protect, and potentially commercialize the IP associated with your invention. A disclosure is basically a narrative of the invention. It includes technical details along with collaboration and funding information. Often the disclosure represents an invention in its earliest stages, so the Technology Transfer Office is looking for the observable or anticipated value of the invention. That helps support their future decisions about how to pursue protection. There may be a few to several discussions and interviews between you as the faculty inventor or researcher and the TTO so they can better understand the invention. This process helps the office take a more informed approach in terms of how to pursue intellectual property protection, or whether there is a better mechanism to allow this invention to have a broader impact. After you submit a disclosure and the office starts the assessment process, part of this process will be to conduct a preliminary patent or IP search. This provides a review of what is currently in the patent database, for example, that should be addressed, for example, freedom to operate, so the office can better understand what challenges might exist if they move forward. In terms of when to disclose, prior to any publication, prior to an oral presentation or posting an abstract, and prior to talking to an outside company or organization. And who can disclose? Faculty, students, and staff or research personnel. After you submit a disclosure and the office starts the assessment process, part of this process will be to conduct a preliminary patent or IP search. This provides a review of what is currently in the patent database. For example, that should be addressed. For example, freedom to operate, so the office can better understand what challenges might exist if they move forward. In terms of when to disclose, prior to any publication, prior to an oral presentation or posting an abstract, and prior to talking to an outside company or organization. And who can disclose? Faculty, students, and staff or research personnel. And if you are a researcher who wants to do a startup or commercialize your invention, there are lots of pathways. You will be engaged with the office to take your startup forward if they decide to protect the intellectual property. Or there may be an opportunity to license the invention to an existing company instead. Some things you may encounter when working with the TTO on a startup: an ownership stake the TTO may request in the startup, specific restrictions or limitations on how the technology or IP can be used. Financial compensation, the startup agrees to pay the TTO ongoing patent prosecution for legal protection, and sometimes a negotiation for a seat on the startup's board of directors.